Aloha. Thank you for joining us today. I'm Bob Girrier, President of Pacific Forum, and it's my pleasure to host this maritime discussion. This is our fourth in the series. It's been almost 4 years now since an arbitration tribunal, constituted in The Hague under Annex 7 of the UN Convention on the Law of the Sea, ruled that Beijing's 9-line claim in the South China Sea is without basis in international law. Has it made an impact? Did it promote rule of law for the maritime spaces in the region? Will Vietnam follow suit and take China to a similar judicial proceeding? For this session, we're going to examine the impact of the landmark 2016 arbitration ruling on maritime security in the Indo-Pacific. Some questions we'll be addressing. Has this legal precedent made a difference? What does it mean for the UN Convention on the Law of the Sea writ large? Has the ruling strengthened international law? What does it say about rule of law versus rule by law? And what more is being done or should be done to build on the tribunal's work? As a reminder, today's session will be recorded. All remarks, including those during the Q&A period, are on the record. Joining us today are two distinguished experts who will help us understand this complex issue and preview the ways forward. I'm delighted to introduce Ambassador Nguyen Thao. Ambassador Thao is the second vice chairman of the UN International Law Commission. He's also an associate professor of international law and Vietnam's foreign policy at the Diplomatic Academy of Vietnam. Prior to being elected to the ILC in 2016, he served as Vietnam's ambassador to Kuwait and also ambassador to Malaysia. He was also the deputy head of Vietnam's National Border Committee and played a key role in the drafting process of Vietnam's 2012 Law of the Sea. Ambassador Thao obtained his PhD in law from the University of Paris in 1996. Also joining us is Professor James Kraska. Professor Kraska is chair and Charles H. Stockton Professor of International Maritime Law at the Stockton Center for International Law, U.S. Naval War College, where he's a tenured full professor. He also serves as visiting professor of law and John Harvey Gregory Lecturer on World Organization at Harvard Law School. There he teaches international law of the sea. Previously, he was a visiting professor at the University of the Philippines College of Law, also a visiting scholar at Duke University and Woods Hole Oceanographic Institute. He's a permanent member of the Council on Foreign Relations. Ambassador Thao and Professor Kraska will speak for about 10 to 15 minutes each, and then we'll open the floor to feedback and questions and answer, and we'll take it from there. So first, let's hear from Professor Kraska. Good evening, James, and thanks for joining us.
Hello, Ambassador Thao, Admiral Girrier. Thank you very much for allowing me this opportunity. Also, hello to Jeff or Daniel and John Bradford for helping to put this together. It's a real pleasure and an honor to talk about the 2016 arbitration and whether it still has relevance for today. So just in a few minutes, we'll revisit the arbitration. So recall that the arbitration determined that the 9-line was unlawful, that it was incompatible with the law of the sea, that the law of the sea is a comprehensive system of rules, and that it's not possible for another country to have any sort of historic or residual rights in another country's exclusive economic zone or on another country's continental shelf. So the internal waters argument for the 9-line was struck down. And also, the tribunal determined that all of the features in the South China Sea would be limited to at most a 12-mile territorial sea. And so this removed any sort of exclusive economic zone rights by China. And what that has done in the aftermath is that it has somewhat pushed China toward a theory of mid-ocean archipelagos, in which China is suggesting, again, quite ambiguously or vaguely, that it has some conventional rights based upon purported title to the features in the region. This sort of novel theory, though, it also fails or would fail if it were subject to a judicial test, because China is not a nation that's wholly composed of islands. And so under Part 4 of the Law of the Sea Convention, China is not an archipelagic state. What it does, though, is it raises a new approach by China, which is somewhat of an abuse of the Lotus Principle, named after the famous 1927 case. The Lotus case said that states are permitted to do those things in international law which are not specifically prohibited. And so while it is true, for example, that the Part 2 of the Law of the Sea Convention does not disallow a 17-mile territorial sea, some Chinese scholars would say, well, if it's not prohibited under the Lotus rule, we could claim that, or a 43-mile territorial sea or a 57-mile territorial sea. Of course, implicitly, a 12-mile territorial sea is allowed, and so all others are not permitted. Likewise, the same would hold true with archipelagic straight baselines and archipelagic claims, that those are permitted under Part 4 for states wholly composed of islands. And while Part 4 doesn't say that states that are not wholly composed of islands may not have those baselines, it's implicit within the text. So in the aftermath of the case, China was rather embarrassed and subject to a fair amount of ridicule, because China is not accustomed to the idea of the rule of law, but rather views law somewhat cynically as a tool by the powerful to control the weak, rather than a mechanism that controls both the strong and the weak alike. And so China views law as a way for the leader, and in this case, China believes that the United States has been the leader in telegraphing expectations to subordinates. And so China has this false equivalency of rule of law and rule by law that Admiral Girrier mentioned. So how would Vietnam fare with a potential case? I believe Vietnam would prevail, even though the 2016 arbitration is not binding precedent. It certainly would be influential to any future Annex 7 arbitration. It was a unanimous decision by some of the most esteemed law of the sea scholars in the world. So Vietnam is similarly situated to the Philippines, and China would not be able to prevail on an historic waters claim or historic bay or title to any of the waters offshore, nor would there be an issue of maritime boundaries that would allow China to accept out jurisdiction under Article 298. So China has very little experience with the rule of law, and it also does not have much experience with balance of power, because historically China has always been dominant in East Asia and has not dealt with countries on an equal basis. This really brings us to my view, which is that law is simply one element of this relationship, and that lawyers and a legal case entirely, of course, will not resolve it. And the West tends to have a view of looking at things atomistically or individually. And this arose out of the Greek tradition. That is, that things are discrete and linear and separate. And a perfect example of this is the US response in the region, which has heavily been focused on the Freedom of Navigation program. There's a great article by Blake Herzinger in the War on the Rocks recently that calls the Freedom of Navigation program an often used tagline that's become somewhat of a tired platitude in the region. And it's used so often by the United States, he says that it's become meaningless. And although I'm a champion of the FON program, I also think that he's onto something, that he's right, that you cannot view the problems in the South China Sea from an American perspective simply as, let's send in another deployment of ships and aircraft, and that will solve it. Another tendency related to that is to view the problems as created simply by the arrival of General Secretary Xi, focusing on the personality. And there's often a focus on personality in the United States with regard to President Trump, sort of an obsession of what is Trump going to do? What did Trump do? And similarly, there's a focus on Xi. I think that this is some small element. It's a focus on Kenneth Waltz's first lens of behavior in international relations. But I would suggest that even if Xi were to leave the scene tomorrow, or President Trump were to leave the scene tomorrow, these issues would very much be persistent in exactly the same form. So I think that this is an issue ultimately of power, and that we ought to look at it not in discrete, linear and stovepipe lines, but rather holistically, that it has a political element, an economic element, a military element. And China understands this, and they've used all of these elements to compel acquiescence on the part of its neighbors, and also even states much farther afield, such as within the United States, influencing Hollywood or sports teams to toe the line of the Chinese Communist Party, or more recently, influencing the statement of the European Union with regard to China. And so China understands and is very effective at leveraging all of these in a coherent fashion. My view is that the United States still has plenty of cards to play. And in fact, it remains in a superior position within all of these elements if it is smarter about organizing and thinking through how to counter China's efforts. First of all, militarily, the United States has the benefit of 5 treaty allies in the area, including Japan, Australia, Thailand, the Philippines, and South Korea. And the United States can get smarter on maintaining and building this alliance structure. For example, I would recommend, when it makes sense, to get rid of the adage that the United States would not take a position on certain island claims, when in the past we have, in particular with the Senkaku Islands, which the United States governed when the Senkaku Islands were under the US jurisdiction when it occupied Okinawa, and also Scarborough Shoal, which was under US jurisdiction when the Philippines was a colony. And so by not taking a position, the United States has actually disavowed its earlier positions. I would also strengthen strategic partnerships that the US has with Vietnam and with India, and implicit security guarantees that we have with Singapore and Taiwan. And there's mechanisms to do so, for example, broadening this security architecture through tools such as the ASEAN Outlook on the Indo-Pacific and associating the US with that. Also economically, I think that China has abused the World Trade Organization. It has not, again, adhered to the rule of law. It has systematically protected its markets and also used economics as a weapon against its neighbors. It is the Chinese Minister of Defense has acknowledged that the One Belt, One Road initiative is linked to China's aspirational expansion for PLA presence overseas as far as the Caribbean and Pacific Islands. And here again, the United States has levers that it has yet to invoke. One would be to take another look and return to the Trans-Pacific Partnership, which would have built economic bridges between the United States and states in the region. And at the same time, that would help to to effect a gradual, partial disengagement with China and the United States, and I believe some other countries as well, as states, particularly now, seek alternative supply chains and shifts in supply chains. There's numerous nations, Vietnam, India, Sri Lanka, the Philippines, that for different products and different services offer attractive supply chains. And in fact, the government of Japan has offered more than $2 billion to its companies to seek alternate supply chains. And so that's something that I think would help with this as well. The other thing is that my view is that we can't blame China for problems of our own making. And one of those is a slowdown in innovation. While it's true that China has, through cyber intrusions and through theft and through unbalanced trade agreements, has extracted intellectual property from the United States and other countries, the United States is also, and Europe especially, have failed to maintain their edge in innovation. In 1969, the United States could put a man on the moon with duct tape and vacuum tubes. And today it seems that it's almost impossible to do so. And my view is the reason is that we have a culture of risk aversion that China doesn't have. And you can see how miraculously with the COVID-19 problem that in the area of pharmaceuticals and testing, that the red tape and the bureaucracy is swept aside. And so we ought to think about doing that for other areas of innovation to maintain and accelerate this edge, this advantage that the US and the West has in economic innovation, and partnering with states that protect intellectual property. So this includes energy, pharmaceuticals, technology, all that are related to building national power. So in sum, I would say that the United States and the West in general have lacked a coherent strategy, that we've suffered from looking at the problems in the South China Sea and in the region individually. And that includes looking at having international lawyers seeking a solely legal solution. And the problems there defy a single solution. They require a coherent approach. Happily, I see that the US administration released just today a new focus on China that appears to be along those lines. And so only time will tell whether that can be operationalized and that sense can spread among US friends and allies. And that will take leadership from an administration that could probably do better in that regard. So thank you very much.
Thanks, Professor Kraska, for those tremendous insights. We'll now hear from Ambassador Thao. Good morning, Ambassador, and thank you for joining us.
By Pacific Forum and YCAPS, and it's a pleasure to join with Professor James Kraska and Rear Admiral Bob Girrier today. So I agree with Professor Kraska that the South China Sea dispute is very complex confrontation, which most party participated and most countries concerned about, including US, EU, Australia, and other countries beyond the region. Professor Kraska resumed the tribunal ruling of the 2016, and now I would like to emphasize only 4 important points of the ruling. So the first, you know that the ruling declares that any historic right based on the night deadline as a maritime claim is contrary to the United Nations Convention on the Law of the Sea and without lawful effects. The second, the tribunal determines that all of the high tide features in the Spratly Island are also rocks which are not entitled to generated maritime zone beyond the 12 nautical mile Children Sea. And tribunal declare also that low tide elevation or submersive features are not subject of territorial appropriation. They are not capable to generate Children Sea, except the case when they are located wholly or partly in the 12 nautical mile Children Sea from mainland and island, and serve as a baseline recognized internationally. So 4 points, so that the Spratly Island cannot be considered as a single unit for applying archipelagic stretch baseline. So that the conclusion of the award are reasonable, fair, and correct in law and facts. It's the first time the tribunal has a clear and direct answer and explanation in detail what's the right implementation of Article 121, paragraph 3 of the UNCLOS, and thereby contribute to the development of the law of the sea. The verdict has not only affect the main stakeholder of the case, the Philippines and China, but also other many countries in the region and beyond, to the project of implementation and development of the law of the sea. So that Vietnam, Malaysia, Indonesia, and other, they're not by the award, but the award can give recommendation to concerned state to accept and amend the position in accordance with the UNCLOS and the award. So the award emancipated cotton state from the overlapping claim from Spratly Island. Now, because there is no any maritime overlapping over the zone economic exclusive and continental expanded from the coastline of Vietnam, from the coastline of the Philippines, and from the coastline of Malaysia or Brunei. Yes, so it's very important. So it's a second point that the award encourages coastal state extending the outer limit of continental shelf beyond 200 nautical miles. It's a legitimate understanding in implementing of the Article 76 of the UNCLOS and rule of procedure of the UN Commission on the limit of the continental shelf. And the award also recognizes the traditional fishing right in some area such as Scarborough, where the Philippine, Chinese, and Vietnamese fishermen can enjoy fishing. It created the possibility to have a joint fishing development mechanism in the center of the South China Sea. And finally, the award provided the possibility to have a high sea with freedom of the sea and area, the common heritage of the mankind in the center of the South China Sea. In other words, the South China Sea, now it is not semi-enclosed sea. It is a part of the ocean. There is also the high sea and area of the common heritage of mankind in the center. South China Sea become more multilateral internationalization than bilateral or regionalization. And in that case, in that situation, the role of ASEAN can be underlined by the award in restraining conflict and developing cooperative mechanism in the South China Sea. Non-claimant country in ASEAN have also enjoy benefit from high sea and area, the common heritage of mankind in the center of the South China Sea. So that it can read that the ruling has played an important role in affecting the political, economic, and security of the country in the South China Sea to internal solidarity of ASEAN, and impact also China, US competition and foreign policy of the country having the right interest in the South China Sea. The ruling, in my opinion, is also the test of credibility of international law, the respect and goodwill of the party in its implementation. The unintended effect of the ruling will also be impact on many generations of the cotton states in the South China Sea, including China, Vietnam, the Philippines, Malaysia, Brunei, Indonesia, and others. Thank you very much.
Well, thank you very much, Ambassador Thao. Very much appreciate the insights. And I think at this point, we're ready to turn it over to a larger question and answer period. So I thank, again, both distinguished speakers for their comments. So using Zoom's features, you can register a question either by virtually raising a hand, and you'll see that on your screens, or by sending us a question via chat. And we already have one that came through. I see that Professor Kraska had answered it, but I want to go ahead and repeat it so everyone else can get a chance to listen to it and also to give the ambassador an opportunity. So the first question from Andreas Aditya Salim, do you agree that establishing an RFMO to regulate the high seas pocket in the South China Sea could be a part of the solution? And this question is to both Professor Kraska and the ambassador.
Thank you, Admiral. My view is that there is not actually a very large area of high seas in the South China Sea, because most of the South China Sea is constitutes exclusive economic zones, principally from Vietnam and the Philippines, and also Malaysia, Brunei, and China somewhat. And so because of that, you could have an RFMO, and that would be a positive development, but most of the fish are in the exclusive economic zones.
Thank you for the question. I agree with Professor Kraska that the South China Sea, which has a breadth more than 400 nautical miles, from the opposite coast, from the Vietnamese coastline and the Philippines coastline mainland. So that with the conclusion of the tribunal, China can extend 200 nautical miles from the Hainan, Vietnam, from the mainland, and the Philippines, from the Luzon and Malaysia, Brunei. So now in the center of the South China Sea, there is a real high sea and area, the common heritage of mankind, in accordance with the UNCLOS. So in the high sea and in the area, all the country inside and beyond the region enjoy freedom of the sea, enjoy the exploitation and exploration of resources in the area. So it is also that like one symbol to unify ASEAN, and now even Myanmar, Laos, Cambodia, and others have also the right to fishing in the high sea. And now it's a question of the fishing is common for all, but not for only Vietnam or only the Philippines. And other countries like US, EU, and others, they enjoy also the freedom of the sea, freedom of navigation, freedom of the overline, freedom of laying of cable and pipeline in the high sea and as the area as a common heritage of the mankind. So now it's a very important point to change the situation in the South China Sea. Thank you.
Thank you. Our next question is fairly technical, but let me go ahead. This came in via chat. So Spratly is not a single unit to apply archipelagic baseline, thanks to the 2016 award. How about the paracels? There is no judgment on paracel yet, and the convention does not specifically forbid that action. So is the drawing of an archipelagic baseline around the Spratlys illegal? And if so, what would the legal basis be for that? And again, for either of you to comment on that.
Yeah. Is it for me or for?
Go ahead, Ambassador. Go ahead, take a shot at it first, and then we'll follow up with Professor Kraska. Thank you.
Yes. Thank you. You know that the archipelagic baseline, yeah, by the Arctic 47 of the UNCLOS applied only for the archipelagic state. So in the South China Sea, only Indonesia and the Philippines have the right to apply the Arctic 47. Yeah. So Baracel, it is the offshore archipelago of the Cotton state. China applies the archipelagic baseline on the Baracel. It is on the overlapping claim sovereignty between Vietnam and China. So it is illegal. Yes, the first. The second point on the technical, yeah, it's violated the Arctic 47, yeah, for the only archipelagic state. And Arctic 47 provide also that the ratio of the land and water, yeah, not except the 9 point, the ratio of the water and land is next, except the night time. Yeah. In the case of Paracel, yeah, the total superficie of the Paracel, there is only 10 square kilometers, while the surface of water enclose 17,000 square kilometers. So it's a very high for the ratio provided by the convention. Yeah. And in the tribunal ruling of the 2016, tribunal condemned also any attempt to consider the Spratly Island as a single unit for applying archipelagic baseline. And Vietnam also and other countries protect the application of archipelagic baseline drawn by China in 1996. And I think that international community continue to protect any attempt to establish archipelagic baseline around the Spratly Island. Thank you.
Ambassador Thao mentioned exactly textbook analysis. The only thing I might add is that there's also no basis for straight baselines in the Paracel Islands under Article 7, which would be normal baselines. And the tribunal had already ruled that there's no historic internal waters, so it's not possible to enclose the Paracel Islands in any sort of historic waters claims. So there's absolutely no legal basis for straight baselines in the Paracel Islands.
So given the rather strict interpretation of Article 121 by the tribunal, what is your view if other claimants in the future claim that the features in the Spratly Islands are able to generate an EEZ and are a continental shelf, based on the arguments that the ruling is only binding upon China and the Philippines? Over to you, Professor Kraska first, then followed by the ambassador.
Well, as you know, neither Malaysia nor Vietnam use the islands in their continental shelf claim. And this evidence of state practice, in my view, combined with the influence of the 2016 arbitration, means that there's really an uphill battle for any nation or country to make a claim that is broader than or outside of the ambit of the 2016 arbitration in the South China Sea.
I think that the question is very clear. Under tribunal ruling, yeah, all high tide feature in the Spratly Island have only the right to generate the 12 nautical mile. Yeah. So that outside 12 nautical mile of the high tide feature in Spratly Island, there are Z and continental shelf of the other coastal state. So that it is a reason why Malaysia extended its outer limit of the continental shelf in the north, yeah, in the December last year. Yeah. And Vietnam and Malaysia submit the joint submission of the outer limit of the continental shelf to the CLCS. Yes. And the Philippines has also the inner tip and Brunei also. Yeah. It's the process forward. Yeah. We can stop this process because it's a legitimate undertaking of implementation of the UNCLOS. Now, only China claim the whole the South China Sea based on the 9 dash line. Yeah. It is a subject of the opposition of the tribunal ruling. Yeah. And other country accept that the feature in the Spratly Island have only 12 nautical mile. Spratly Island are not considered as a single unit for applying the archipelagic baseline, and all want to have a peaceful settlement of the dispute in accordance with the UNCLOS and tribunal ruling. And UNCLOS can be considered as the sole legal basic for settlement of maritime dispute in the South China Sea. Thank you.
Thank you, Ambassador. I've got two hands raised, but actually I've got one very straightforward question that came through on chat I just want to get to for the Ambassador. And straight up, Ambassador, will Vietnam file an arbitration case against China?
Yeah. I think that before arbitration, Vietnam has a very clear position. Yeah. When Vietnam accepted with Malaysia to submit the file of the outer limit of the continental shelf to the CLCS, yeah, so that extended continental shelf measure from the mainland of Vietnam and not with the withstanding with any legal effect from Spratly. So that in that case, Vietnam support Spratly Island has only 12 nautical miles. Yeah. And in 2014, when the tribunal sent the note to ask the opinion of the other concerned state, including Vietnam, Vietnam noted that Vietnam were no doubt on the jurisdiction of the tribunal, and Vietnam considers that all features mentioned by the Philippines in the file have only 12 nautical miles. So that I think that Vietnamese position is consistent with the position of tribunal before the ruling accepted. Thank you.
Thanks, Ambassador. I'm going to switch over to the raised hands. We've got two. I'd simply like to remind all that when I do call on you, please make your question or comment as concise as possible. We have over 120 participants, and we have actually quite a queue generated now in the chat. But let's go over to Jay Tristan.
I'm Commander Jay Tariella of the Philippine Coast Guard. Thank you, Ambassador Nguyen and Thao and Professor Kraska for their really illuminating presentation. I would like to address my question to Professor Kraska. As you may be aware, Coast Guard agencies are being developed by various countries in East Asia and Southeast Asian regions. Interestingly, United States Coast Guard has been actively engaging these agencies, and its ships are being deployed in the region too. As for China, it has continuously relied on China Coast Guard ships in patrolling and harassing fishermen in the South China Sea. My question is, do you think it is more appropriate in the context of the international law for a state to utilize white hulls in patrolling disputed waters like in the South China Sea? My second question is, does it matter if the state uses gray hulls or white hulls to maintain its effective control in these contested waters? Thank you very much.
Thank you kindly for the question. So obviously the white holes reduce the temperature somewhat from military assets, and therefore they're less destabilizing. But of course, China is using white holes in sort of a new and unique way in order to make strategic gains with assets that normally are considered law enforcement assets rather than strategic assets. So in some respects, there is a benefit, but I would hold off on the celebration. And I think that states have to use all instruments of power, and that means they also have to increase the size of their maritime law enforcement capabilities. I believe the United States, Japan, other countries have assisted states in the region in doing so. There's much more to be done.
Thank you very much. Next, we'll go to John Barnett. And when we unmute you, if you could just state your affiliation as well. Thanks, John.
My name is John Barnett. I'm a professor of political science at Emporia State University. And it's a very simple question. From my understanding that China has been disputing this area really since 1974, and it was due to oil. What's the relationship with the law of the sea and oil reserves that are in the South China Sea? Who really owns them? I guess that's the question. It's never been answered in all the research that I've done on this topic. Come on, Lam.
Okay, go ahead, Ambassador, if you go first, followed by Professor Kraska.
I think that the South China Sea is very important, not only for oil and gas, for fish resources, but it is a strategic position of the South China Sea. It's a South China Sea is like one bridge connecting the Indian and the Pacific Ocean, so that the South China Sea, it is behind of the China. It's like it Caribbean to the US. So China always want to have established the dominance, the full control in the South China Sea. So it is the main reason for the conflict, all the conflicts in the South China Sea. Yeah, and we would like to have the goodwill and full respect of the international law from the all cotton states, including Vietnam, China, and others. Yeah, thank you.
And Professor Kraska.
Thank you for the question. So there's actually not a lot of oil, turns out, in the South China Sea compared to other areas, particularly when you find oil prices in a world glut of oil. Most of the oil that is in the South China Sea is actually relatively close to the coast and would be even outside of the claimed 9-dash line or dash line in any event, and certainly outside of lawful exclusive economic zones. My view is that the issues in the South China Sea have very little to do with oil for China. The amount of oil that's in the region is important for the developing states of the Philippines, Malaysia, Brunei, and Vietnam in particular, because even though there's not an enormous amount of oil, it makes a big difference to those smaller economies. For China, it's much less so. There's not enough oil to begin to satisfy the Chinese market. So for China, I agree with Ambassador Thao. It's much more about the strategic location, both as a waterway, as the ambassador mentioned, but even more so, in my view, is as a buffer, as an area, an extended area to be out to the first island chain to build, if you will, a wall or a Great Wall encircling China, and to keep potential influence of the United States or other countries away from China.
Thank you, Professor. Our next question, I have a raised hand from Mataki Kamiya. If you could state your affiliation, and we'll go ahead and unmute you as well.
Can you hear me?
Yes.
Okay. Matake Kamiya, Professor of International Relations at National Defense Academy of Japan. As everyone on this, internet conference knows, China has recently declared that they are going to set 2 new administrative districts in South China Sea area, claiming that the entire South China Sea is China's territorial water. And my question is very simple. Does it show that the 2016 arbitration has failed to influence China's behavior in the South China Sea? Or can the 2 speakers point out if the arbitration made a difference in China's behavior in this sea area? Thank you very much.
Ambassador, if you take that first, followed by Professor Kraska.
Yeah. You know that in last month, China had conducted a series of acts. It is establishing the 2 new districts in the Paracel and Spratly, and also naming of the submersion features on the continental shelf and EEZ of Vietnam. So it is a very dangerous action to trigger the conflict in the region. Logically, when one country establishes administrative unit, they will continue to declare the limit of the administrative unit. So that we talk about the archipelagic baseline of the Spratly that China has intention to draw around the Spratly Island. We talk about the possibility of the ADIZ, Air Defense Identification Zone. So that I think that China may apply the future measure to confirm they present in the Spratly Island. And of course, other country don't support this very unlawful intention. Thank you very much.
Thank you for the question. I might add to that for China, it's 2 steps forward, 1 step back, as the saying goes. And this is this recent announcement is, of course, patently unlawful. China claiming the largest city in the world with an area of 2 million square miles. And what it suggests is that, especially for Americans and for the West, that we have to get rid of this idea that we're going to find anytime soon, at least, a solution. And Americans like to identify problems and then fix them. And they also tend to sort of invest suddenly and wholeheartedly in an effort. And then when something can't be fixed, like Iraq or Afghanistan, then they walk away, or even Vietnam. And so I would not look at this establishment of some sort of new administrative region as anything profound, but rather a continuation for the struggle for influence and the struggle to shape the law. And in that case, the states in the region and US and Western states ought to have sanctions or consequences and treat China just like any other country. And so imagine if Russia had done something, or Iran had done something similar, and what would be the consequences that flow from that. And that's the sort of new and creative thinking that I would recommend.
Thank you. Our next question comes from Kentaro Furuya. And if you could also please state your affiliation and whether your question is to both panelists or one. Thank you.
Good evening, Professor Kraska, and good morning to Ambassador Thao. My name is Kentaro Furuya. I'm a teacher and professor at the National Graduate Institute for Policy Studies and Japan Coast Guard Academy. Thank you very much for your presentation. My question goes to both of the panelists regarding what the regional state should do to attract China to observe the rule by arbitration. After the arbitration award was made, Beijing said that arbitration award was just a piece of paper, and then a continued reclamation activities to construct military bases in the island. Professor Kraska correctly pointed out the US Navy carried out a series of HONOPs in South China Sea. But what option should regional state take for Beijing to observe the award? That's my question. Thank you very much.
Thank you, and thank you, Kentaro. It's good to hear from you. So I guess what I would say to both of these questions, and what can regional states do and what can the US do? And it gets back to my original comment, which is that the United States and the West and its friends and allies are still stronger than China. And so China will try to impose consequences. Think about, for example, the market manipulation and the market costs that China tried to threaten regional countries with. The banana shipment out of the Philippines, for example. And so in my view, the United States has to understand that when states in the region stand up to China, that they have to do so carefully. Neither China nor those states are going to go anywhere. And so they are permanent neighbors and they have to live with one another. On the other hand, the United States and states in Europe and elsewhere, Australia, Japan, can help ameliorate any sort of blowback by China, for example, by opening up their markets to goods that might have otherwise gone to China, and thereby help them strengthen and embolden them. So with direct assistance, military assistance, which we're doing to some level, we talked about Coast Guard cutters, different maritime law enforcement assistance. All of those, that sort of direct assistance is good, and then indirect assistance to help to inoculate and embolden the neighbors of China to be able to not acquiesce and to say no.
I agree with Professor Kraska, and I would like to add the history of jurisprudence here. You know that in the history of the international proceeding had some cases of non-appearance before the international jurisdiction organ and rejection of jurisdiction, such as the case between Nicaragua and US in 1986, the case between Greenpeace and Russia in the case Arctic Sunrise 2013. Yeah. So, but with time and pressure from the international community, country concerned cooperated to settle the dispute under the ruling of the court or tribunal. And now China has an official position 3 known, no acceptance of jurisdiction of tribunal, yet no appearance and no implementing the tribunal award. Yeah. However, we hope that international the international community will have a pressure enough on China to accept the tribunal award in the future. Thank you.
Thank you. I'm going to switch back to chat now. We have several in the queue, and we still have 15 minutes worth of time, so that's a good thing. This question, again, for both panelists, and I'll tip it to the ambassador first, followed by Professor. The question is related to China's push for joint or cooperative hydrocarbon development. And the question is, would bilateral or multilateral hydrocarbon development involving China be helpful or inimical, excuse me, to the observance of the 2016 award? How can littoral states ensure that it would not prejudice the legal effect of the award? And over to you, Ambassador first, followed by
you know that joint development is one of the provisional measure provided by Article 74 and Article 83 of the UNCLOS. Yeah. China launched the joint development initiative with three elements: China sovereignty, putting aside dispute, and joint development. So that the precondition of joint development for China, it is the sovereignty of the whole, the South China Sea belong to China, but not for other country. However, as you can see, that the South China Sea is a common sea for 10 states and territory about of the South China Sea, and also for the other country beyond the region. So that we have also, we welcome joint cooperation on the basis of respect, of mutual respect of sovereignty and sovereignty right of each cotton state, and for mutual benefit. Vietnam has also some experience to have a joint development with other country, like with China, joint fishing zone in the Tonkin Gulf, with Malaysia, and with Cambodia also. So we are welcome any participation from outside on the basis of respect of sovereignty and sovereign right of the coastal state defined in accordance with the UNCLOS. Thank you.
I agree with that. Right now, I think that China has not shown itself to be a reliable partner. Another example is from outside of the area in the East China Sea with the Japan-China boundary, where China has in place numerous drilling platforms right up on the line, and also appears to be drilling even on the Japan side of the line. So unless there were some additional evidence of sort of a greater recognition by China to deal fairly and in a balanced way with its neighbors, I would not recommend joint development at this time.
Thank you. I'm scrolling through the chat here. I have one from Asura Sala, and the question is, some countries have found it challenging to effectively maintain and preserve marine life in joint marine protected areas, such as the Turtle Islands. How feasible would it be to achieve regional consensus and coordination in establishing an RFMO? And I'll lead off with Professor Kraska, then back to the ambassador.
Thank you. My point of departure for all of these sorts of questions is whether the regional states outside of China can come together with some sort of agreement first. And this would be true with an RFMO as well. If it's possible for Vietnam, the Philippines, and Malaysia, possibly Brunei, to develop a package agreement and adopt some sort of agreement, then they would, of course, be in a much better position acting as a group collectively. And that would attract a lot of buy-in from other states. And the question is, are they able to do that? And so for me, that would be a prerequisite for the development of such an agreement.
Hi, related to your question, I think that now China and ASEAN has a very effective mechanism on negotiation on the code of conduct, on the conduct of the party in the South China Sea. Yeah. So if we want to have an agreement on consensus on the solution of the South China Sea, it is necessary to step by step to establish the confidence building measure like a code of conduct, and after that, the other country must reconsider their position in accordance with the UNCLOS, because the UNCLOS it is a sole legal basic. It's a constitution of the ocean for the all country in the region and in the world, including China and all the claimant state in the South China Sea, ASEAN, US, and other. Yeah. So only when we have the goodwill, we will achieve the consensus and to find a reasonable solution for any conflict in the world. Thank you.
Thank you. We're running near the end of time, so I'm going to go through a handful of questions. I hope do our speakers have a pen and pencil handy to jot down some notes? So I'll go through a few here, and then I'll turn them over to both of you. The first one, when I break, this is for Professor Kraska, and it's if the U.S. abandons its neutral position regarding sovereignty of several features in the South China Sea, will it cause tensions among various claimants other than China? So just if you could hold that question, I'll get to a few more here. And this question is specifically for the ambassador. So this question is, again, for Ambassador Thao. What do you think about the prospects of Vietnam taking legal actions against China? There have been some hints that this may be the case. Are there any indications that Vietnam is actually preparing for a case? And I think you may have covered a little bit of this earlier, but if you can expound. This question is regarding a code of conduct for the South China Sea and the issue of power, or would it really be a futile exercise? So the question is there hope in the ongoing negotiations regarding code of conduct? And that's for both the professor and the ambassador. Let me grab one more. The question is more specific. Does China's Coast Guard meet the definition of a warship? It is now under the military command. In other words, it's not specifically a military, but it is a state vessel. Not to mention the military standard weapons being installed on board its various white-hulled ships. So is there a difference or a way to distinguish between gray hulls and white hulls? And how does that impact the issue? Let me just pause for both of you. We'll start with Professor Kraska and then Ambassador.
Thank you. Thank you, Admiral. So my view with regard to abandoning the issue of not taking a position, I'm not saying that for every single feature, of course, in the South China Sea, just the ones that the U.S. had taken a position in the past, in particular Scarborough Shoal. And the problem is, yes, it would create more tension. And that's the price you pay for changing your earlier position. Just like not conducting fauna operations and then suddenly conducting one 5 years later is going to create tension. That's just an unnecessary price that would have to be paid for walking away from the earlier position. And greater tension could be constructive in the long run is what I would suggest. With regard to the code of conduct, I would defer to the states in the region on that. From an outsider's perspective, color me rather skeptical. It's been 20 years in its formation. And my view is that if China had wanted such an agreement, there would be such an agreement. I think it's principally a theater of dialogue, and states in the region may think that there's some value in that. There could be some tertiary value, but I wouldn't hold my breath for an actual agreement anytime soon. With regard finally to the last question, as the Admiral said, it is a state, the Coast Guard ships are state vessels. And the question would be, are they considered auxiliaries? Most likely they're auxiliaries, even if they're with the PLA Navy or under the PLA Armed Forces, which means that they do not enjoy belligerent rights during an armed conflict. Nonetheless, that's somewhat of a technical legal issue, and I'm not convinced that that would restrain China in any event.
Thank you. Ambassador, if you'd care to comment on any of those, that last round of questions.
Yeah. So related to the question on the possibility of Vietnam have a lawsuit against China, I think that Vietnam has a position to apply the Article 33 of the UN Charter, and also provided by Article 74 and 83 of the UNCLOS, yet to use all peaceful means, including conciliation, mediation, yet participants of the third party international organization, yet to peaceful settlement of the dispute. Yeah. I would like to quote it, the speech of the Vietnamese Deputy Prime Minister and Minister of Foreign Affairs Phạm Bình Minh. He declares on May 8, 2020, yeah, with the time 75 years from the end of the Second World War, on European soil, lesson learned from the preventing future atrocities, responsibility of the Security Council. It's a conference organized by the Security Council. He declares that the defeat of the fascists and aggressors in the Second World War, and indeed all the war and conflicts, proven that action driven by expansionist, militarist, and the taste for conquest and dominance can never be the will of nation to fight for their independence and freedom. And Vietnam believe as our common human aspiration for peace, freedom, and justice, and our determination to defend our independence, sovereignty, and territory will prevail over confrontation, the use of force, and attempt for domination and conquest. Vietnam preconize the direct negotiation, and it has a lot of experience to settle the dispute with the neighbor country, with China in the Tonkin 2000, with Indonesia on the continental shelf 2003, yeah, with Malaysia, with Cambodia, yeah, and so on. So that I believe that Vietnam continue to use negotiation and diplomacy is the main tool to defend its interest and legitimate concern in the South China Sea. The lawsuit proceeding, yeah, it is only the last resort when all other means, peaceful means of settlement are exhausted. Thank you very much. And for the COC, yeah, I think that we need to have negotiate goodwill and restraint in the negotiation on the COC. But for the COC, I don't have any information because it is a secret process. so I cannot further analyze. Thank you very much.
Well, we're now at the end of our time, and I'd like to thank both of our distinguished speakers for your time, and also to our participants for some very stimulating questions and a good exchange back and forth. This concludes our session today. Again, the session was recorded. These remarks are on the record, and they'll be available at our website. And I'd also like to thank our supporters, our partners in this discussion series, YCAPS, the Yokosuka Council on Asia-Pacific Studies, who's joining us again in this whole discussion series. Thank you both for taking the time on your busy schedules, and again, very much appreciate the exchange today.
Thank you, Bob.
Thank you.
Thank you, Kraska. Yeah. Okay.
Thank you, Ambassador Thao.
Good.
Thanks for joining us, folks. This concludes today's session.